Welcome to the Brigham Young University Family History Library webinar series. My name is Braden Knudsen. I'll be your host for this webinar. I would like to welcome everyone here and ask you to answer a couple of our poll questions we have down at the bottom. How did you hear about us and where are you listening from today as we go through a few of our announcements. Our next webinar will be on Thursday, January 19th at 10 a.m. Mountain Daylight Time, and that webinar will be by Catherine Grant, so we'd like to invite everyone to join us on Thursday as well. Also, Roots Tech is coming up at the beginning of February. If you have not yet registered and you're planning on attending, you can go to our um, main website and there's a link there to register for that event as well, and it will be really good. We'll be there. You can come see us, come meet the people behind the webinar program. It'll be really fun. So today we'll be pleased to hear from James Tanner, who will be giving a presentation titled Legal Notices for Genealogists, Sheriff Sales, Repossessions, Bankruptcies, Debt Collections, and more. James Tanner has a bachelor's degree in Spanish and a master's degree in linguistics from the University of Utah. He received a Juris Doctor degree in law at Arizona State University. He served for 2 years as an intelligence analyst for the U.S. Army and 39 years as an Arizona trial attorney. He has previously owned a retail computer business and an Apple Macintosh software company. James has over 35 years experience in genealogical research and is an avid blogger of Genealogy Star blog and Rejoice and Be Exceeding Glad. He served for 10 years as a missionary at the Mesa, Arizona Family Search Library and is currently serving at the BYU Family History Library. He has presented at expos and conferences around the U.S. and Canada. James has 7 children and 33 grandchildren. Okay, loads, we'll just remind everyone that we do have a comments box and also a questions box over on the right-hand side for you to write in and participate with us today. So we'll turn the time over to James now.
Howdy, this is James Tanner, and welcome again to another webinar from the Brigham Young University Family History Library webinar series. Remind everyone that these webinars are recorded and uploaded to the BYU Family History Library YouTube channel. It's on youtube.com, and you can view them there. We have now close to 230 videos up online, and we appreciate it if you would subscribe because that allows you to know when the new videos are uploaded. We're going to be talking about legal notices for genealogists, sheriff sales, repossessions, bankruptcies, debt collection, and more. You might ask yourself as to why we would want to do this. What is the interest in these particular documents? They're not particular. I would assume that even among people who are very, very avid genealogists, they have not really looked at a lot of these kinds of documents because probably because they don't know what they are, and secondly because they don't appreciate perhaps the importance of the genealogical information that's contained in these documents. For years, as far back as there's been property ownership, probably thousands of years, there have been people who are trying to repossess their property. If it didn't get sold, I guess, paid, I guess as long as people have been accepting mortgages and time payments where you buy on time, they have also had to have debt collection and notices from legal notices are the byproduct. So we're going to kind of get into this in some detail here. This is not going to be sort of superficial view, but we'll talk about some of the more important possibilities here. Now, legal notices are usually associated with court actions. So they aren't necessarily regarded as court documents because many of these notices appear in newspapers. The ones that you're not likely to see, by the way, are those that are actually posted on property or posted at the courthouse. There's various ways of giving notice for legal actions. If any of you are familiar with a probate action, for example, probate actions in the courts, everything that happens in a probate action has to be noticed. The procedure there is that there's a number of documents. So let's suppose that you're in a probate action in the court, and as a result of the probate action, there's some disagreement over the disposition of a certain piece of property. Who's going to get the silver teaspoons or whatever? Yeah, that's exactly what happens. And the question would be, how do they go about doing that? Well, the person who is representing the estate is the one who may or may not become aware of the dispute. But let's suppose that someone says, I want to have the silver teaspoons. The other person in the probate action says, well, I want the silver teaspoons. Well, either one of those individuals could go to the court and petition the court for a hearing to ask for evidence as to who should get that particular piece of property. And so that person, say party A, who is claimant under the probate action for some kind of property interest. This could be someone, for example, a creditor, even someone who says that the property that the deceased owed them money, and there's a dispute as to whether they did or did not. And so the person there would have to go to court and petition the court for a hearing, which would be an opportunity to come and talk about give testimony or talk or argue back and forth about who should get the property or who should be paid. And in order to do that, they have to give notice. Now, what does that mean? Notice means that anybody else who may be out there interested in that particular estate has to be given notice of that particular action. And those notices in every place in the United States and in most of the European countries have to be have some very specific ways of being publicized. First of all, notice has to be sent to all the parties involved. Anybody who is actually designated as a party in interest to the proceedings. And then it is often necessary to include additional notices. In the United States, it's not unusual that in a probate action that any hearing has to be noticed through a publication in a newspaper. In addition, in many jurisdictions, and going back many hundreds and hundreds of years, maybe even 1,000 years, legal notices such as that have been required to be posted on the courthouse in some location, and usually they used to say the courthouse door, but today we don't have doors that you would post anything on since they're all glass doors anyway. So what we have is bulletin boards and places to publish these legal notices. So these kinds of things happen as a result of being associated with some type of court action or some kind of legal action. Most of the time, these legal notices are required by the law. In other words, there are specific ordinances or statutes that require notice to be given. If you live in the United States of America, you probably have noticed legal notices being posted around your community on various occasions. If there is a change in the zoning, how some property is going to be treated by the city or the state or the county, then there may be a requirement of the law that a notice be posted. I see these quite frequently as I drive around. I'll see a legal notice application for building permit, or a legal notice application for a liquor license, legal notice application for a variance in the zoning regulations. All of these things get posted on the property themselves. What you may not know is that also in most jurisdictions, those same notices have to be posted in a newspaper of general circulation in the county where the property is located. So if you go into the newspapers, and perhaps you've read a newspaper where you've looked at the back where the classified sections used to be when we had newspapers. No, not all of them have disappeared yet. But in the old days, those legal notices would be published at the back of the newspaper. You'd see a whole section of legal notices, and then there'd be classified ads. Interestingly enough, the newspapers today are basically losing money because they are losing classified ads and legal notices. So these two items, that there's different ways of requiring. There's also an interesting development in the law that has of late indicated that in some cases courts have held that notices can be posted on Facebook, on the internet, for legal proceedings. This has happened in some divorce proceedings and some other types of actions where people have gone into court and argued that the opposing parties or the interested parties would only see the notice if it were posted on Facebook. And so this is, things change, but the fact that notices are required does not necessarily change. Um, the interesting thing about all of these is that these types of notices is they're useful for a number of things, and more primarily from our perspective as genealogists, they're useful for establishing ancestral identity and locations. Primarily the location, because if you find, for example, a notice of a foreclosure on a piece of property, you certainly know where the property is, and you'll know the identity of the owner. So these are the kinds of things that you can learn from looking for legal notices and making sure that you understand exactly what the legal notices means. And in addition to this, they often lead to additional records. For example, a notice in a newspaper, as I mentioned a moment ago, of a dispute of a hearing to be scheduled in a probate matter will lead you to the probate. You'll be able to find the probate. If you find the probate, you likely will find, if there was one, you will find a will. And if you find a will, you'll probably end up identifying various individuals in that particular family. So these legal notices are really pretty obvious evidences of additional information that can be learned. So as I mentioned, these legal notices were often and most frequently actually published in newspapers. Now, the postings that were made on the property and the postings of notices that were put on the courthouse bulletin board, or the courthouse door, as they say, are probably not going to be preserved. In other words, the record of that would be in the court record. Generally speaking, if any notice is required by law, then there is a requirement for what's called a return. And the return means that the person who was required to make the legal notice has to go back to the court and report to the court that the notice was actually made. And in many cases, the court cases particularly, the notice has to be provided back to the court by the person who published the notice. So, for example, if the sheriff is required to give a notice of a sheriff's sale where a judgment has been entered against a piece of property, and then the sheriff is required by law to hold a sheriff's sale or an auction to auction the property off to the highest bidder. Then when the notice of that sheriff's sale is posted, the sheriff who made the notice has to make a return to the court. That is, provide the court with a copy of the notice that was posted plus an affidavit, a sworn statement that indicates that the notice was put on the courthouse door or whatever else, put in the newspaper. Routinely in probate actions, notices that appear in the newspaper and also in actions for repossession and bankruptcies and things like that, all of those notices that end up in the newspaper are also going to be copied and filed with the court. There has been for the last probably 100 years a formal type of return that was required by each of the courts. Courts have different procedures all across the country, all across the United States and around the world, and even can vary from county to county. But according to the local rules of whichever county you're concerned with, the form of the notice may differ, but the idea that a form must be filed with the court with a copy, in this case a copy of the notice to creditors or whatever, or taxpayers, that appears in the newspaper must also be recorded. Now, the ones that I have up on the screen right now, the one on the left is a notice to the taxpayers of Apache County, Arizona, that tax assessments and tax roll of the county for the year 1915 is now in possession of the tax assessor. So this kind of notice will lead to other property notices. For example, it was not uncommon in the same newspaper in Apache County to find notices that taxes had been unpaid. So if you failed to pay your taxes, they'd print it right there in the newspaper that the following people have failed to pay their taxes this year on their property. It was interesting for other people because there is a procedure, for example, that underlies these tax notices where once a tax has been assessed, the tax becomes what's called a lien. A lien, that's an L-I-E-N, or lien. There's lots of ways that people say that word anyway. But the lien against the property was a legal claim by the governing taxing entity against that piece of property. And the liens are then recorded. Now I haven't mentioned recording yet, but some of these notices end up being recorded. That's with the county recorder's office, and those are official recordings that remain in the record over a long period of time. If the action deals with real property, then those notices and the claims are recorded against the real property, and then they become a matter of record. So you can actually see if your ancestor was late on their taxes, or if they lost their property because of a foreclosure on a mortgage or something like that. Now the other one on the right-hand side is also it's a court notice, and that's a notice to creditors. In this case, it's talking about the estate of someone named Franklin Wiltbank, and he's deceased. And this is one of the notices that's required in the course of a probate case. At the beginning of a probate case, the representative of the estate, whether it's an executor because they have a will, or an administrator because there is no will, or as they're now called, personal representatives, are required by law to give notice, general notice, to anyone who may have a claim against the estate. This is called notice to creditors, and it has to be published in the newspaper, and then a return of the publication, meaning an affidavit or sworn statement that the notice was actually given, has to be filed with the court. So there's a whole subset of procedures that go along with each of these kinds of actions that generate documents that can tell you information about your ancestors. In this case, this one on the right-hand side, it talks about the estate of Frank Wiltbank. It also tells some more information, and it also indicates who the administratrix, in this case probably the wife of Franklin Wiltbank, and the date would give you not only give you the information concerning the name of the wife, or potential name of the wife, or a daughter, or whoever was related, but it would also give you the court in which you could go look for, and the specific time period that would give you access to the probate records if they exist. So it's not just casual kind of information. This is really something that will have a direct effect on your ancestor. Now, one thing you can do to find out what kinds of things you need to look for is to just look up the laws regarding publication in the county or state where your particular person was located. So if you know generally what the publication laws were, then you will also know that where to go look for the information. Now, here's the thing. In this case, this is a general publication law, and it says that the number of times that the notice has to be published, and if it's a weekly newspaper, once a week for 2 weeks. If it's a daily newspaper, 4 consecutive times. If the place of publication is not specified, it'll be like in a newspaper printed and published within the county where the state capital is located. if a county officer or board or et cetera, et cetera. If you read through all of these things, you'll find out some interesting things. That one that I just read really quickly is important because let's say um, your person lives in a small county in the South in Mississippi, and they happen to have this rule as their state rule on publication. What it just said was that the notice has to be published in the county where the state capital is located. If your person doesn't live in that county and you've searched your county for records, guess what? You should have been searching in the county where the state capital was located at the time that the person was living there. And if you're like Arizona and Utah, we've had state capitals move around a bit. State capital in Arizona started out in Prescott and then ended up in Phoenix. And the state capital here in Utah started in Fillmore and ended up in Salt Lake City. So depending on the time frame, where if this rule were in effect in that state, in either of those states, then the notice would have been filed in a different county perhaps than where your ancestor lived. There may also be additional notice requirements that require the notices to be published in the county. Now, another thing that comes up that's over the years that's been interesting for genealogists because they generally are not aware of this kind of thing. There is a rule in Arizona, for example, and it's a general kind of these kinds of things. When I give an example for a local state or county or whatever, you can assume that you're going to find very similar provisions all across the United States and England and most of Europe. There's going to be very similar things. The United States, by and large, didn't, when it became a country separate from Great Britain, did not necessarily invent all of its laws over again. It basically copied what was in England and Spain and France and a few other places. And so most of these requirements go back into antiquity, probably much further than any of most genealogists would be doing research. In addition, the notice requirements are pretty much general the same all across the United States. So you can always assume there was a notice requirement. So all you have to do is just do a little bit of historical research into the laws and figure out where the notices would have been published. In Arizona, and this is another example of a local rule that may be in effect all across the country, is that notice is required to be made in a newspaper of general circulation in the county. Now, the fact that we don't have any newspapers of general circulation in the county anymore, no, we might, but the rules have got to have changed. But we're not really, genealogists, we're really not too concerned about what's happened the last 10 or 15 years. We are mostly interested in what happened 100 years ago, or 50 or 100 years ago, or even further. But this was a catchphrase, a newspaper of general circulation in the county. Well, I lived in and worked as an attorney in Maricopa County, Arizona. And Maricopa County, Arizona is one of the largest counties in the United States, population-wise, and actually size-wise. I mean, there are a few counties bigger, but Maricopa County is bigger than some states in the United States. It's a huge piece of place. Well, the capital of Arizona is Phoenix, Arizona, which is about the 6th largest city in the United States. And they had probably a dozen newspapers. There was one newspaper called the Legislative Review that basically would publish nothing but legal notices. So if you really wanted to get anything out of it, you could go to the daily newspapers, the Arizona Republic or the Phoenix Gazette, and get legal notices. But if you really were looking for legal notices, you went to this this business review, business paper that published just nothing, almost nothing but legal notices. But we were always looking at the law, and the point here was we needed to fulfill the provisions of the law, but we also didn't want to spend a lot of money doing it. And the cheapest place to advertise legal notices, you might take this for a hint to genealogists who are doing research, was a newspaper published in Gila Bend, Arizona, which is about 75 miles south on the south border of the county, out in the middle of the desert. It is a place that you can drive through in about, if you're on the freeway, it takes about 2 minutes, maybe side to side to get across the entire uh, town of Gila Bend. It is not what you would call a prosperous community. It is. It looks like something out of the 100-year-old past when you drive down the main street. But anyway, that newspaper was the one we used to publish all of our legal notices because it was the cheapest place and because we really weren't interested in having people notice our legal notices. We just were fulfilling the requirements of the law. You'd say, well, that's just like attorneys trying to make some sneaky way to get around it and try to avoid. The answer is yeah, that's the way it worked. And you can assume that that's the way it worked with all the other people trying to give notices back through the 100 years. So if you assume that because you've checked the General Register or the newspaper, the people with the newspaper with the largest circulation in the county, you've missed the boat, folks. You really have not found where they're going to publish these. Now, notice is legally required when certain actions are taken by the court. Now, that's what I've been explaining. So anytime the court does something, it's going to give a notice of what they're going to do. So if the court holds a hearing or a trial, there's going to be a notice of the hearing or a notice of the trial. If the court issues a judgment, there's going to be a notice of entry of judgment. If there is anything the court does is going to require a notice. So these notices can go all sorts of places, and this is what I'm trying to talk about here is that genealogists should be out there aware of all of these various notices that could apply to their families and their ancestors throughout the United States and into Europe and other countries. And even when certain types of cases are filed. Okay, now bankruptcy. Bankruptcy is a classic example of this. In order for someone to claim bankruptcy under the laws of the United States, they must give notice, all sorts of notices, notices to any kind of potential creditors, and they have to publish these, and everybody has to know about it, because you're not going to allow people to discharge their debts through a bankruptcy proceeding without giving their creditors an opportunity to come in and either dispute the division of the property or otherwise make a claim on the property. So there's a long list of legal provisions for making notices in that type of case, in a bankruptcy case. And I've already mentioned probate cases where the notices are regularly given for various different phases of or actions taken in a probate case. All of the other actions have a debt collection. If you file a lawsuit to collect a debt, once again, there's a whole series of notice requirements that are prerequisites before you can file the lawsuit. Sometimes you have to actually do all the notices before the lawsuit can even be filed. And when the court issues an order of the court, for instance, distributing property in an estate or declaring bankruptcy for an individual, all of these notices will require all of these actions by the court will require some kind of notice to be given or published or posted. And often when you ask the court for a ruling or a request a hearing or some other kind of action, there are additional notices that have to be given. Is kind of an aside, as an attorney practicing as a trial attorney for an extended period of time, one of the things that was the most, whatever you want to call it, bothersome, burdensome, drove us crazy, was all of the notices that were required. And one of the reasons why legal secretaries had nervous breakdowns was because they would forget to do a particular notice and then have the attorney go ballistic when they found out that their lawsuit had just been jeopardized because some notice hadn't been given. So most of legal assistants today, we don't call them secretaries anymore, legal assistants would be very, very hyper. This is how they maintained their job. A legal assistant wouldn't last a week if they missed a notice, but if they could keep giving all the notices and keep the attorneys in practice without getting in trouble, then they usually could keep going indefinitely. And one of the reasons that, in fact, they had very good job security, actually, because if they got known to being what you would call a good legal assistant, which meant from the attorney's standpoint that they could remember all this stuff and make all the postings and know what the time periods were, which they, by the way, would usually have big charts on their surrounding their desk showing all the time periods on everything, so they knew what to publish. So, it's a pretty important thing, and that's why it becomes important to genealogists. Okay, time for some definitions, so we know what I'm talking about here. First of all, court file. The court file, when you refer to the court file, what we're referring to is a physical file. It's all the documents associated with a legal action. Now, the way the courts file these, in other words, the way they keep track of their court files, varies across the country. Some of them put them in chronological order, some put them in alphabetical order by the name of the parties. Some of them maintain them based on an arbitrary filing number that is assigned when the first document is filed. All different ways. So you can there's always some way to locate the documents, even if they're just in a pile in a box in the bottom of the courthouse. Minute entries. A minute entry is this is a kind of an interesting term. What it is it's an order from the court or some kind of information from the court. You would think of it as a memo or some kind of a record of what the court did, but that's exactly what minute entry is. It's just a record of some action the court took. And the court can say something like, the court has reviewed the case and noted that nothing has happened. They put out a minute entry. Okay, so you'd think it's really silly, but sometimes that helps the people to get busy and get the case resolved. A pleading. Pleading is a word that refers to a document that's filed with the court requesting some sort of action on the part of the court. And I might mention this just for clarification. When attorneys speak of the court, and I say filed with the court, I mean filed with a particular judge who has been assigned to the case that I'm working on. So the term the judge and the court are kind of synonymous. They mean the same thing. So when you say filed with the court, you mean you're filed with the judge. One of the things that happened to me when I first began practicing law was very, very early, because I was in law school. I went to work for some law firms as a clerk. This was called clerking for law firms. You get paid to be a gopher. You go out and do whatever they tell you to do. So even though my father was an attorney and I had been in courts and I'd seen trials and I'd seen all sorts of things. I knew generally what attorneys did, but I certainly didn't know any of the details. And I went to work for a law firm and they said, could you go downtown and take this down and file it with the court? This documents. In fact, they gave me a stack of documents. They said, here, take these down and file them with the court. I said, sure, I'll be glad to. So I jumped in my car and I went, what am I supposed to do with these documents? Being a male and B, an attorney, a potential attorney, you were not going to sit there and ask questions about people. Well, I learned a lot differently after I'd been in that situation for more than a couple of months. I learned that if I didn't understand anything, boy, I made sure I understood what they wanted me to do before I did it. But I got down to the court and I walked in, and there's, it's a big building in downtown Phoenix, and I walk into the building and there's people standing around and there's lines and there's all sorts of things. And so I asked somebody, I said, I need to file this, where do I go? And they said, get in that line. So I got in the line for filing. I finally got up to the front of the line and I had all my documents and I said, I need to file these documents. And the court official, the person who was sitting on the other side, said, well, hand them to me. So I did. And I said, well, then what? And he said, well, you just did it. So filing a document with the court means you hand it to the court official who is entitled to receive the document. Okay, simple. Anyway, in this case, they had to stamp it all in with a date stamp, and then they gave me back the copies that I was supposed to get, and that was the end of it. Okay, notice. Notice is a document or procedure given notice of something happening in a court case. Well, you say the word notice. Yeah, notice means notice. Notice doesn't necessarily there's in the law there's a distinction between legal notice and actual notice. Okay, and we would get into arguments continually over whether or not the parties had actual notice of something. When we talk about actual notices, whether they learned about it, they knew about it. On the other hand, legal notice didn't matter whether they had knew about it or not. So, for example, if you're sent a certified letter by the IRS trying to collect taxes from you, and you sign for it, they don't care if you open it or not. You don't have to look at it and know what they want you to do. All they care is that there was some official uh, opportunity for you to learn about it. So notice is not necessarily notice. Just because I I publish it in a newspaper, it doesn't have to be actual notice. So, for example, the earlier example I gave about using the Gila Bend Sun newspaper for our publications, um, the thing about that was that the legal notice was fulfilled by giving the notice in the newspaper. That didn't mean anybody ever saw it, but you couldn't argue. In other words, the people, like a creditor or whatever, to the estate could not argue that they didn't that oh well I never saw it, so I don't have to. I'm not prevented from making my claim. Well, the answer was that these people who were the big creditors, like banks and other people who were actually interested in whether or not they were going to get paid, would hire companies, full extra companies, who would do nothing but go through all the newspapers and all the printings in the entire state of Arizona, for example, and would then cut out and copy and send out all these to their clients. Their clients were the banks and other creditors who might have claims. So there's a whole business out there of people providing notices. Today, the same people are online making sure that any online notices that are made. So for example, if the person fails to pay their taxes today, it's posted on the county assessor's website. Well, I may not know to go to the county assessor's website, but somebody does, and if I pay that person enough money, or if they have an interest, they may send me a notice and tell me that that was printed on the newspaper. So these are the kinds of things. The attorneys, the more you know, literally, the more you know about these court procedures as a genealogist, the more likely you are to actually find your people, because this is where um, most of the people of the world ended up in the court system sometime or another. More definitions. Proof of notice. This was the return that I'm talking about. When they talk about you need to file a return or a proof of notice, that meant the document was filed with the court telling the court that the notice had been provided consistent with the requirements of the law. This is usually done in an affidavit format, meaning that the signature was notarized by a notary or made under oath. A court order is a ruling by the judge making a decision as to some aspect of the case. So basically, you can get a court order is not necessarily the final judgment of the case. It's not what disposes of the issues, but it is it is part of the action of the court. And a return of service. Sometimes the notices had to be formally served. Okay, so if you were starting a lawsuit, for example, and you file a document called a complaint or a petition or whatever type of action it was, and there are some different names for it. So you file a petition for a probate, but you file a complaint in a personal injury action, for example. when those documents are required, you have to give notice of the filing of the lawsuit. So basically, the way that you do that is you create what's called a service of process. And people who do this are either court officials or process servers. They are required to actually physically, under a whole bunch of rules, different rules, hand a copy of this document to the person that's being sued. And so the return of service is they're informing the court that this process has been properly conducted and the person has been served with that particular document and notice has been given. Now, when I say these things, all of these different types of documents will appear in the court files. And rather than just flip through those pages because you don't know what they are, or flip through them because when you're examining a case file because you don't think they contain any information, you need to look at these carefully, because a notice, a proof of notice, might give you the address of the person who was served, in which case that might identify that person with enough particularity for you to distinguish between someone else that you're looking at who had the same or similar name in the same area. Now we're down to notice of publication. I talked about that. I think I've said enough about notices of publication, but it's the same thing as a return of service, but in this case, you're notifying the court that the document or whatever has been published. Now, traditionally, these notices, as I mentioned, have been given on the property or at the courthouse. Here's a copy of a sheriff's sale to be held back in 2013 that was posted on a piece of property. Now, the sheriff's sale in this case is an action to sell the property, either to satisfy creditors or because of a foreclosure on a mortgage or something like that, which is also a creditor, by the way, or because someone has obtained a judgment against the property and they're selling the property to satisfy or pay the judgment. And in most cases, notice is still required beyond this, beyond notice given in the courthouse or on the property itself. So what kind of legal actions require notice? I've mentioned quite a few of them, but we'll just run through some. The answer is nearly everything. There isn't really any court action that I'm aware of that doesn't require some kind of a notice, whether it's formal. Almost all formal notices in addition. Informal notices, during the conduct of a lawsuit, it was not unusual for the court to call the judges, the attorneys on the phone and say, we need you down here for a hearing this afternoon or tomorrow or the next day or whatever. That can happen. And it most frequently happened in criminal cases when there was criminal action, that you would get called sort of out of the blue by the court to come down and attend some kind of a hearing. But most of the time they were formal notices that became part of the file. Now, I've noticed in some of the really old law cases in the United States, when I've reviewed the files, that of course everything was handwritten back then. There were no printed documents as such. But the courts had a tendency to copy the stuff into the court record. So sometimes as you're reading through the court record, you'll see just a notation that says notice was given a certain date by so-and-so. And that's maybe all that you have that some kind of notice has happened. And as I've mentioned also, there are different ways to give notice of legal action. Here's one, for example, probably on a zoning action. Yes, this would be development services, and this one, I can't read exactly where it is, but there was an address, but it's obviously someplace in 503. It's actually California. Okay, this one turns out to be in California. So this is sort of a public hearing notice, and it's posted on the property. So we have posting on real property. We can deliver the notice in person. An attorney, for example, is required to give notice to all the other parties of a lawsuit. And on every document that I filed with the court, there was always what was called a mailing certificate or a certificate of notice. And that mailing certificate we had to put on there and said we actually sent this out to everybody who was concerned. The lawsuits always, in those kinds of lawsuits where there were multiple parties, generally there would be a whole page or two or three. Some lawsuits, like the bigger lawsuits in the state of Arizona, like that I was interested in, like the Little Colorado River adjudication, which had probably a couple of hundred or more people involved in that lawsuit. There were copied pages, like 5 or 10 pages of of the lists of people, double-sided, of all the people who were being given notice. So there was a massive amount of mailing that went out on those lawsuits. By the way, those huge lawsuits like that are another really good place to do research about your family if somebody was involved in one of those big lawsuits, because they'll be get constant notice. Mailing is always one way that they've used mailing, posting in or on the courthouse, literally on a bulletin board attached to the or on the door of the courthouse. Now, if you happen to be Lutheran, or even if you know some history of the Renaissance, you'll know that the Reformation, excuse me, you know that Luther posted his notices on the door of the cathedral. This was not an accident. He didn't just do that to get attention. That was the legal way of giving notice at the time. So you can take a hint from that this is something that's gone on for quite a while. Email today. Today, everything by the time I finished practice, all of the courts in the state of the Maricopa County, all of the courts in Maricopa County, in the main county in Arizona, had become what were called e-filing courts, meaning they didn't take any paper anymore. You had to do everything through filing online and filing notices. A court ruling on avoidance. Okay, now this is complicated. If you were trying to serve somebody and they were hiding away or trying to prevent you, which, by the way, happened extremely frequently in filing lawsuits, and especially things like foreclosures and debt collections and things like that. There was a news thing on the news here in Utah just recently about some lady who a repossession company who had been trying to repossess a car and had chased a lady down the street, and the lady ran into a tree and got killed or something, and now the repossession company's being sued. Well, that's called avoiding service of process, or avoiding the being served with a lawsuit. And the court can rule, for example, if you cannot be found in the state or you're avoiding process, they can require the process to be given what's called alternative method of service of process, or alternative notice, which would give you the ability to go take some other method, like posting in a newspaper, or some other method, that mailing out by certified mail or whatever, not usually registered mail, that would give you, in which case the court would then rule that the person had notice, whether they actually received notice or not. So there's ways to get around this, avoiding people who try to avoid getting involved. Now, in this case, a proof of the notice, meaning the document with the notice, and a copy of the notice is filed with the court. So these are things that are going to end up in these huge case files that are things. And further, the court may acknowledge the notice with a minute entry. So there might be some minute entry telling that so-and-so received notice, and maybe going into detail about how that notice was given and what it was. The notices of proof of, and the proof of notices and minute entries can be in the court file. Now, some courts, after the cases are ended, will, in a sense, strip out everything except the main pleadings. I've seen this in some of the historical courts records that I've gone through. That all of the day-to-day minutia, the types of stuff that was being done, are missing from the court action file. Okay, so this is an example of one of the types of documents that could be filed, proof of notice. And sometimes the courts separate their pleadings, which are the documents filed by the attorneys, from the court documents that are filed, called minute entries. So when you go in to look for court records, you may have to search both the pleading file and the court file. One gives you the procedural documents that were filed to keep the case moving through the court, and the others are all the substantive documents that were filed by the parties detailing their arguments and their claims. So these are the kinds of things that you need to be aware of, that there are other places to go. Now, my suggestion on court files has always been, for genealogists, is to search carefully through the entire file. This is a screenshot of a court file in on the FamilySearch.org website, and it can be found in the FamilySearch.org catalog. And so this is the whole. This is a microfilm copy of a digitized copy of a microfilm copy of a court file, and each of those represent a page in that court file. So you have to be careful that when you're going through a court file, you start at the very beginning, find the first document that was filed, and then through the end of the file when it is finally ended. I did a video some time ago about probate, and one of the things that I noted in that probate series of videos was that I used an example of a probate file that lasted for 30 years here in Utah County. That was filed and never was closed until 30 years later. So once you think you've gotten through the file, you better make sure that you get to the absolute end of the file, because later in the court's stack of documents you may find more and more information as you go along, unless it actually ended. And even when they end, they may not end. So what's a sheriff's sale? When a person owes money to a creditor, someone who claims money, the creditor can go to court and get a judgment for the amount of the debt. Once the judgment's obtained, then they can try to collect the debt by forcing the sale of any or all of the debtor's property. And this is called a sheriff's sale. These go back to antiquity. If you read the old, if you're ever back in the novels, even like Robin Hood, back in the early days of England and medieval days in England, they were still doing sheriff's sales. They were still trying to evict people and sell off their property. So, this is really something that's been going on forever. Here's the procedures for obtaining. First of all, a sheriff's sale. First, they vary by county and by state and by country. So every time you go in and do some research, you're going to have to figure out how they did it differently. Usually only available after a judgment is entered. Its application for a sale and notice are always required, and sometimes these were only posted on the courthouse, so you may not have a record of that in the court file. And the sale was usually conducted by a verbal auction held on the steps of the courthouse, literally standing out in front of the courthouse. Now in Arizona, in Phoenix, we did not stand out in front of the courthouse. It was 115 degrees. And so those were conducted inside the courthouse in a usually big glass, like a mall, glass enclosed area. But literally we would have the sheriff walk out. He'd have a stack of paper and he'd start yelling out names, and people would mill around and bid on the properties if they were interested in. I always had people who were trying to convinced me that a good way to get rich quick was to go down and buy property at sheriff's sale, and I was always telling them, I know too much about it. I'm not worrying about that. After the sheriff's sale, there's usually a time when the property could be redeemed, the redemption period. So you have to be aware of the fact that there may be additional documents even after a sheriff's sale. And if the property is not redeemed, The sheriff issues a sheriff's deed to the property or pays the cash proceeds minus the cost of the sale to the creditor. Okay, in this case, the documents are going to show up in the recorder's office with those if it's real property and not just personal property like a car or a wagon or a horse or whatever, then it would be it would show up in the recorder's office with the land and property records. What's a repossession? It's the forfeiture of property and the failure to pay according to the contract of sale. So if you fail to pay for your car, eventually somebody will come around and take possession of it. It's called repossession. It can be real property or personal property. If you're purchasing a piece of property on a contract rather than under a mortgage, then your contract of sale may allow for certain procedures to gain possession of the real property if you default in paying on the property. Or if it's a mortgage, there are standard legal methods for repossessing the property after a default under a mortgage. Everybody has their own rules and procedure. They vary significantly across the United States and around the world. There's nothing that the idea that there is an idea of a repossession, yeah, that everybody has that, but the way you go about it is vastly different, even from county to county sometimes. Repossession of real property may involve a loss of all the personal property on the premises. Pretty severe. And often involves an eviction where they're trying to get the person out of the property. So from our standpoint, as genealogists, what most people consider to be really bad news is really good news. The worse the people have legal problems, the more they're in court, the more property they lost, the more times they went bankrupt or whatever, the easier they are to find. It's just the way things work. Okay, an eviction is when you get somebody off a property, and this is something, by the way, that I was involved in rather consistently and over a long period of time. And for as negative as it may sound, it is really more negative than it sounds. It is really not the funnest thing that ever happened to the world. And it was usually for failure to pay rent or purchase of real property. And it can help on, sometimes in the United States now, they allow what's called self-help. And historically, they could actually do that. If a person failed to pay the rent on their property, the landlord could, they had what was called summarily eviction, a summary, I can't even say that word anymore, getting old. It was a eviction done without any kind of action by the court. So they could just go in and throw the people off the property, and that would happen. So you could also do it without a formal demand or notice. So if you didn't pay your rent years ago, the landlord could show up and throw you off the property. That's kind of actually that's the theme of a lot of the drama in early American literature is people being evicted from their property. Bankruptcy is where you go to a formal court action. Now, you can't get bankrupt in a local court. The United States, for example, and some other countries maybe also, the federal government, the United States government has preempted all bankruptcy. So now it's a federal action. You have to file in a federal court. And if you owe more than the value of your property and your assets, then you're technically bankrupt. So you can go to court and do it. In the old days, it was like death. It was the worst thing that could happen. Today, there are serial bankruptcy people. We have a 7-year cycle in the United States on bankruptcy. So you can refile every 7 years. I knew people that had refiled every 7 years for their whole adult lives. Okay, and they're not usually found in any of the large online genealogy databases. Really, you do not find this stuff in Ancestry, Family Search, or any of the other big companies. This is not something that they've ever really gotten into as far as genealogy. The specialized bankruptcy records are kept in the National Archives or other repositories, and they may be closed and not available to inspection, at least going back a few years. Eventually, they all become, you can get into most of this stuff, but they may be difficult to get to, by the way. They're not so easy to find. And go to the National Archives to find this. Bankruptcy procedures are extremely complex and specialized, usually heard by special courts, and they involve an extreme dislocation and impact on the families involved. Historically, all sorts of people were involved in evictions. One person I read about was Daniel Boone, who was a famous American kind of explorer, Indian explorer type person. The real history of his life was that he never managed to get legal title to any of his property, and he kept moving west because he kept getting evicted and ended up on the banks of the Mississippi River as an old man without any property. Pretty sad story, but that's really what happened to Daniel Boone. Involves a lot of paperwork and notices of all kinds. And debt collection is legal action to enforce a debt. I've already covered some of this, so I'll go through this pretty quickly. Can be judicial or extrajudicial. Extrajudicial means self-help. Repossession is an example of self-help. They can call a company a repo specialist who can go out and pick up the car even without any kind of notice to courts or claims in court or anything. So it's called self-help or extrajudicial repossession. So there's this self-help provision in the law, and it's a very common. They're usually handled by justice of the courts in the United States, or local courts. They're usually called a justice court. And unfortunately, for a period of time in my legal career, my partner and I handled like 150 or 200 of these a week. And we had huge piles of paper. He did most of it. I did the ones that were complicated or required, or had people who showed up in court and cried and threw themselves on the floor and stuff like that. So it was pretty dramatic. Where are the records kept? They're all mixed in with all the other court records. They're usually not separated out and may not be court records at all. So there's where to search first. Okay, this is the reality of it. Look in the newspapers. All of this stuff's going to end up in the newspapers at some point in time. And when I say newspapers, like I mentioned earlier, all the newspapers in the county, because they can show up anywhere in a county or even the state. So it can be a long process, but it's worth it because you do find this information. Court records, wherever they're maintained, and that's another part of genealogy, is learning where these records are kept. Land and property records, they're the same things, and a lot of these are going to talk about it. So do not discount the value of court records. They are extremely valuable in helping people to locate, find, and discover information about their ancestors. Not all of it's really positive or good, but it's helpful. Okay, thanks for watching. We will post this on the BYU Family History YouTube.
Okay, well, thank you very much, James, for the wonderful webinar. I hope this has been helpful to everyone that's participated. If you didn't get a chance at the beginning to answer some of our polls here at the bottom of the page, feel free to do that now. And also, if you have any questions, feel free to write those into the question box, and I'll make sure those get answered before we end the webinar today. As James said, this webinar will be posted onto our YouTube channel, so if you want to come back and watch something again, if you missed something, or if you want to share it with a friend, that would be great. And we hope to see you next time.